The Honorable, the Supreme Court. Representing the appellee, Mongeon Bay Properties, LLC, is Attorney Alexander LaRosa. Seated at council table with Attorney LaRosa is Attorney John Mizuki.
Okay, thanks very much. We'll hear from counsel for the appellant first, of course. Please, for the record, start by introducing yourself, identify your client, and then proceed.
Good morning, Mr. Chief Justice, and may it please the court.
Thank you.
I am Brian Mongeon. I represent the appellant, Town of Colchester, in this proceeding today. Sometimes trial courts make mistakes. That's why we are here today. The town is here in an effort to correct a mistake. The town appeals the trial court's decision, which the town contends was deeply flawed, where the trial court considered the town's efforts to use its considerable power of eminent domain to effectuate the public good. The trial court's decision was flawed for 5 different reasons. First, it applied a non-existent statutory framework to its evaluation of the case.
Was that the need for perfection? Was that the?
That's exactly right, Justice Cohen. And in particular, the statute requires simply a reasonable showing of necessity. It does not require a perfect showing of necessity. And that is exactly what the trial court did in its decision in this case.
Is there a subjective component to a perfect showing of necessity? Or is it just, would it be with precision?
I think with some precision is the answer, Your Honor. I don't see how there's really any objective analysis. It has to be subjective here. The court's analysis has to depend on a variety of different situations. What is the piece of property like? What is the taking authority's needs in the circumstances? So those are all subjective considerations. The problem is that the trial court went a little bit too far in its analysis.
But couldn't we look at the trial court's decision as saying the town failed in its burden to show that it had really considered alternatives in reaching its decision to pursue this particular property?
You certainly could, Your Honor, but the town's contention is that that would be the incorrect mode of analysis on appeal. So,
but why is that incorrect under the statute? And the statute says that the town has to show public good, that necessity, and there's a number of factors that it considers. So why doesn't that automatically imply that you can't just pick one property and say this is going to be it? You have to show that you went through some considered process.
yeah. Well, there's a considerable record. There was a bench trial in this case, and there's a significant transcript that is now part of the court record. And that evidence did get in front of the court. The court either did not consider it or rejected it. And we really don't know because the court's decision did not genuinely adequately address those issues. The town's contention is that, of course, it did present that evidence at trial, and the trial court either rejected or didn't consider it. And we really don't know because the decision is really, it's not a shining example of what a party expects in going through a case like this and what the parties should get in terms of complete factual findings.
There's a suggestion here that the town was threatening eminent domain proceeding in order to get a voluntary conveyance of the property. And if I recall correctly, the briefing from the appellant appellee, I should say, starts out with that very phrase. What should be made of the allegation that this is done under threat?
This court should take absolutely nothing from those allegations. And the fact of the matter is, there are conversations between lawyers that happen all the time leading up to or as part of disputes in situations like this. And lawyers speak hyperbolically. That's what we do. That's what we're doing today. We're speaking hyperbolically. I expect counsel for the appellee to do the same. Lawyers do that. The fact of the matter is that—
Well, wait a minute. You know, lawyers use hyperbole, but there are limits. There are limits to that. There are ethical limits to that. And let's be clear about that, particularly in front of an audience like we have here today. There are ethical, very, very clearly defined ethical limits to the use of language, the use of hyperbolic language, if we're going to use that word. Certainly in argument to this tribunal, and in the same respect to in argument to a trial court as well. And I'd like you to just acknowledge that after what you said a minute ago.
Chief, I speaking on behalf of the town, could not agree with you more. Absolutely agree with you. And further to this, I want to be clear that at trial, the appellee's former attorney agreed on cross-examination that the discussion about potentially taking a piece of property was something that the parties were doing, and acknowledged that the use of eminent domain is one of the tools that municipalities or other taking authorities use in the context of these discussions.
Okay, but truth-telling is in fact what this process is all about. I just want this to be very, very clear. This is a process where telling the truth is what we're here for. We're not here to listen to a lot of statements that are blown out of proportion. We want to hear what the truth is. We want the facts. We don't want hyperbole. I just want this to be very, very clear between you and me. Okay?
That's a point that's very well taken, Chief.
Thank you.
I appreciate that.
All right. Thank you.
And specific to that is that we conducted a trial, which is, of course, a truth-telling exercise.
Yep.
And the town, in fact, presented considerable evidence about why it believed it was appropriate to take this particular property and why it had undertaken the necessary studies and evaluations prior to so doing.
Well, that's part of, I'm sorry, but let me, that's part of what makes this a fairly complex case, is that this is not just a simple condemnation case. This is a condemnation case with many other implications having to do with the Clean Water Act, with the town's responsibilities to maintaining a safe infrastructure for persons of the town. I think that's what makes it a very complicated case.
I agree with you, and that was my thinking as we went to trial and as we prepared for today. And certainly it is a complicated case, and we believe the town demonstrated all of that. And the trial court really gave no credence to that evidence whatsoever and did not address why it was not considering the important need for the town to do this under the Clean Water Act.
Counsel, I'm not sure that the court as this court has ever ruled explicitly, at least not in its exact area, but does the town dispute as a legal matter that a bad faith taking or a taking done in retaliation for the exercise of a constitutional right, that would be a defense to a taking? You don't dispute that, do you?
Well, Judge Tomasia, we dispute that to at least a limited extent. I think this court has nibbled at the edges of that in either 1995 or 1996 in the Chittenden Solid Waste District case. And it said, the court talked in its decision a little bit about the hearing is an appropriate matter to consider bad faith. The problem with what that opened up and what the appellee took advantage of at trial is that what the appellee did and what the trial court took up that invitation on was to really get into the motivations of the town. And that we don't think is what this court decided in the Chittenden Solid Waste District case. Really, the trial court's analysis ought to be confined strictly to the reasonable need analysis, and is there reasonable need? And in particular, the town's biggest issue with this is that the consideration of public good. The trial court in this case made a decision that reducing liability as one component of the town's decision was somehow an ulterior motive. That is a novel argument, and that is an argument that this court has never countenanced. Reducing liability fits neatly and squarely into the statutory framework, which requires that the trial court consider public good. There is certainly nothing ulterior about considering public safety and reducing liability for the town of Colchester and its taxpayers. And the town's request to this court is that the court adopt expressly the concept that the public good includes the concept of reducing liability and improving public safety. That is not an ulterior motive, and the town takes great issue with the trial court's consideration of that. An ulterior motive.
What consideration did the trial court give to safety?
We don't believe the trial court gave any consideration to safety. The town's perspective is that in this case, there is an inappropriate mixing of public and private uses, which the town seeks to eliminate essentially, where you have a private residence located on top of a municipal public works asset that could potentially cause danger to people who living or residing inside it. And the town wants to extract those two uses from one another. The trial court didn't consider that whatsoever in its decision from what we can see. And we think that's a critical issue that this court ought to consider here.
Thank you.
But your burden here, it seems to me, I mean, this is an appellate court. The two of you, the town and the homeowner, are basically fighting over the findings. The trial court's made the findings. If they're supported by the record, it's not up to the appellate court to reverse those findings. So isn't that the biggest hurdle you have here? The findings were solidly against you.
I could not agree with you more, Justice Johnson. That is the biggest hurdle for the appellant in this case. The problem and the reason that occurred is because the trial court simply looked at this case through the wrong lens, the wrong legal lens. And by doing that, it allowed itself to make these factual findings that were just utterly inappropriate in the circumstances.
So how do we get to the point where the findings by the trial court were clearly erroneous?
First of all, as to this public safety issue and public good concept, the trial court essentially jettisoned the concept of public good, which in the statutory definition in section 3601 makes clear that public good is really the paramount consideration for the trial court. The trial court, as far as we can tell, really did not consider this public good concept, at least in a holistic fashion. It focused instead almost entirely on the economics of the issue. And economics, of course, we concede it's part of the issue. It's a critical part of the issue.
Well, counsel, didn't the court also say you didn't actually prove your safety concerns as a matter of evidentiary points, and that there'd only really been one problem with this pipe in 40 years? And isn't that really part of the problem, dealing with the findings on that area?
I agree, Judge Tomasi, that is part of the problem. And the town's perspective is that the trial court simply got it wrong. There is considerable evidence in the record. I was reading the transcript this morning as I prepared for the case, and I looked at the testimony of both the town's public works director, who had more than 30 years of experience on this issue, the town's expert engineer, who was in fact present in the 1990s when there were road subsidences and slope failures in this area. The court didn't even talk about those issues. The town has absolutely no reason why the court didn't address those issues, but those issues went entirely ignored in the court's decision-making process, and the town cannot figure out why. The town put forth adequate, substantial evidence, and instead of listening to these experienced engineers, both of whom have 60, 70 years of collective experience in their roles, the court credited essentially a rookie engineer with with her testimony instead of those folks.
You see, you've got 2 minutes.
Yes.
I did not alert you before we started. I hope you were aware of this. We've got 2 minutes.
I understand, Chief.
It's my,
I'm going to, I'd like to reserve my time if I can.
Sure, yeah.
Thank you so much.
no, he held on
Okay.
reserve.
All right, thank you. We'll hear from counsel for the appellee. Please come on up. And before you start, please introduce yourself for the record and identify your client.
Good morning. My name is Alexander LaRosa from the firm MSK Attorneys in Burlington, Vermont. I represent the appellee in this case, Mongeon Bay Properties, LLC.
Thank you.
Justice Johnson asked a question about the standard of review, and that's where I begin this morning. Standard of review is very clear. Necessity, this court has said, is exclusively a question of fact to be determined by the trial court. That's Surasimo 139 VT 594. Trial court's findings on necessity are to be upheld if there's any competent evidence in the record to do so. You're on an abuse of discretion standard, and there is no clearly untenable basis to overturn the trial court's findings in this case. Findings of fact must be viewed in light of the most favorable to the prevailing party, and if there is any evidence in the record to support the trial court, should be upheld.
Mr. LaRosa, someone could read the trial court's decision to say that it went out of its way to rule against the town by making findings, including the finding of punitive action, retaliatory action, credibility, and the like, to stop the project. Would that be an abuse of discretion?
Justice Cohen, I don't believe the court did that. I think the court reviewed the evidence in front of it. It made clear credibility determinations. The town had the burden at trial. The statute places the burden on the town without deference, and the town did not carry that burden. The court exercised its obligation without an abuse of discretion to review the record and make findings and credibility determinations on the record in front of it. Bad faith, as this court has said in CSWD, is an element of the trial court's consideration. The court's exact quote was, in that case, to Justice Tomasi's prior question, if the court finds bad faith by a condemner, the result will be a failure of necessity, ... That's CSWD 163 VT 85. So I don't believe the court abused its discretion in any manner in addressing those issues. They were before the court. They were in Mongeon Bay's objection to the petition. They were before the court. They were tried without objection below. No objection was made by the town during the presentation of that evidence.
What's your definition of bad faith?
I think it falls into, you know it when you see it. In knee binding versus Howe, the court identified that it is the trial court to infer and determine from the record. My definition of bad faith is if a party like Mongeon seeks redress in court, the town and the condemning authority, using its great power of eminent domain, retaliates.
Yeah, but I looked at Black's. Here's what Black says bad faith is: a dishonest belief or purpose, a sustained form of deception associated with hypocrisy. How's that sit with you?
Well, if we're here to tell the truth, Justice Reiber, as we talked about before, I
Well,
think that
there's no if about it, please. It's not if.
call it a hypothetical if, call it a true if.
Yeah.
I believe that definition lies comfortably with me with these facts. I believe if you look at the petition
That's
filed,
pretty strong language.
I understand that.
It's a pattern. A pattern.
I
Dishonest belief or purpose, a sustained form of deception associated with hypocrisy.
believe the record would support that in this case,
Okay.
Justice.
Okay.
And if you would allow me, I think
Yep.
if you look at the petition filed, the court found that not to be true. The town did not genuinely seek to take this property for stormwater management purposes.
But didn't the town need to take some property, need to do something for storm management protection?
Your question has two parts to it. The answer as to did it need to take property for stormwater management purposes, the answer to that question is no.
But it
The
needed-
2017 scoping study and the 2020 PCP, both of which are of record, analyzed mechanisms for the town to achieve its phosphorus reduction targets without taking any private property. Included in that was an evaluation of stormwater treatment practices in the relevant drainage area, the MB09 drainage area, and it included no taking of private property. And it actually, as adopted by the town and after the proliferation of those studies, would exceed the phosphorus reduction targets without taking any property. So the town there's ample evidence that the town can meet all of its targets and exceed them without taking any property, particularly 885 East Lakeshore Drive.
Let me ask you this. If the town, if the town loses this case, can it proceed again against your property on a different basis for condemnation?
The answer is probably yes.
You're-
I'm not, without waiving any
I
objections,
mean,
the answer is
they would
probably
still have to
theoretically yes.
meet the statute.
There obviously would be res judicata or collateral estoppel effects, but in theory, probably on a hypothetical answer to your question, if I'm truthful, is yes.
Thank you.
We're operating off from findings of fact that are made by the trial court. What obligation does the trial court have to make findings of fact on the whole panoply of evidence? In other words, can a trial court ignore certain testimony, just not address it? And then here you are on appeal saying, well, there's no findings of fact on that point.
In the trial court can credit testimony and assign credibility. That is a determination for the trial court. I don't believe it has to, in its findings, address every element of testimony. I think the court can address the elements that are dispositive and reach a conclusion based on that. And I believe there's precedent that says if a trial court can reach a dispositive conclusion with adequate findings, it need not address every element in the case. In this case, the trial court addressed the critical elements, addressed the credibility, did not find the testimony of the town credible, did credit the testimony of Mongeon's expert, which relied on the report, which was admitted without objection by stipulation, and did provide adequate basis to reach its conclusions in the record. I understand your question, Justice Eaton, and I believe the answer to your question is provided that the trial court has an adequate basis for its decision and there's competent evidence in the record to support it, the decision would stand without addressing every single witness testimony element.
Case decided solely on the trial court's finding on burden of proof
Yes,
and only on that.
it could, yes.
Wasn't there sufficient evidence to show that the town presented evidence why they needed it there and why it was important?
I don't believe so, Justice Cohen. The town had a burden. That burden was not met with the presentation of credible evidence. The court heard the evidence, did not find that the town presented any credible evidence or witness testimony that the public good was achieved with this project. It's vastly less effective and vastly more expensive, which is part of the statute under 3601, parent 4, I believe. And the trial court considered that there were a multitude of available options to the trial court, to the town. So the court undertook its analysis, reviewed the town's evidence, and ultimately determined the town did not meet its burden. That is the trial court's obligation and a necessity determination. That is a finding of fact that it reached.
Counsel, I know it's not an area of deference, but at some point, perhaps the town has to choose between two different alternative projects and both have public goods and public benefits and detriments. At some point, doesn't the town get to make the call?
This goes to the question, and I apologize, I forget which one of you honorable justices asked this earlier. Reasonable need versus absolute need. There's an interesting discussion about that. Obviously, at some level, any town undertaking a good faith analysis will, or any condemning authority, there's more V-Trans cases in this regard, will ultimately doing a good faith analysis be presented with a collection of perhaps equal options. And any number of factors could factor into that decision. And it is the town's burden to prove, or the condemning authority's burden to prove, that in light of those options, the project proposed is reasonably necessary to achieve the aims. So yes, but that's not deference. And that's different than deference. The burden here is on the town to even get to that stage. And the evidence does not support that. The evidence here is that when the good faith analyses were done, 885 was not one of the 34 best projects for stormwater treatment practices. I see I have 5 minutes. I'll do my best. And it goes, Justice Tomasi, to one of the undercurrents, is that the town here believes it is true if the town says it is true. And that is not the law. That is not due process. The town's presentation was, we say it's necessary, and so it is necessary. The town miscast the evidence on appeal. But at an undercurrent, the town's belief is if I, as the government, say this is true, it is true. That is not due process. That is not the record. It's not what we stand for. That is not what this court has ever stood for. It's not what due process entails. The town had its opportunity to prove its case, and it did not do that. It did not present credible testimony. The record supports a conclusion accordingly. And the trial court's findings are adequate and sufficient. The record is very complete that the town does not and did not meet its burden, but that Mongeon did prove, in fact, that there was no reasonable need or necessity to take this property. And it is not deference to say, because I say so, it is true, which is the undercurrent of the town's position here. And lastly, Justice Eaton, I do want to point out that it was not a suggestion of a negotiation over taking the property. To be clear, the statement was, if you sue, if you exercise your right to petition the court for redress concerning damage to your property, the town will take your property by eminent domain. There's no public policy served in ignoring that in a condemnation case. That is the exercise of a great power of the government in retaliation for exercising constitutional right. That is a defense to condemnation. This court has said so, and that should not be and cannot be ignored. The court relied on that, which is uncontroverted testimony in the record.
So in your view, that goes well beyond hyperbole.
It goes well beyond hyperbole. That was made as a threat, and it was made twice.
Counsel, leaving aside this case for just a half a second, as a general legal matter, would addressing an issue such as a blighted property or avoiding future liability generally be a properly considered public good for a municipality to consider in a takings analysis?
My answer to your question is, I think Kelo speaks to that quite extensively, and I am unfortunately Vermont has dealt with the Kelo, which dealt specifically with taking for a blighted property for economic redevelopment. I believe Vermont passed an anti-Kelo statute, which applies to some condemnations. It doesn't apply to roadway condemnations. So my answer is more nuanced. I think there's obviously an ability for a town to take certain property. Blighted property becomes challenging under Vermont's anti-Kelo statute, Justice Tomasi. I think fundamentally, the standard of review here is very clear. I think the trial court exercised its discretion in a manner consistent with the record evidence and reached a conclusion that must be upheld. There's no public policy in supporting the town's position here. The town had its chance, did not prove its burden, and I ask that the court affirm the trial court's decision. Thank you for your time this morning.
Thank you very much. How much time does the appellant have, please?
Appellant has 1 minute and 45 seconds remaining.
Counsel.
Thank you, Your Honors. I'd like to just use my remaining time to speak to questions from Judge Tomasi and Justice Johnson, particularly Judge Tomasi's question about essentially who gets to cast the die here. And of course, it has to be the taking authority that has the opportunity to say, this is the property that we propose to take. These are the reasons why we propose to take it. But the trial court abused its discretion by going and considering an alternative that had nothing to do essentially with this particular property. And certainly we could still be in trial today if we considered the efficacy of all of the possible alternatives, because in the world of public works, there are always alternatives. The only thing that separates us between completing them is essentially resources. How much will we pay to build a public asset? Or what efforts will we go through to get there? And the town already made that consideration when it showed up at court. And the appellee really did not attack the need for it. The appellee simply said, you could do this other project over here, and the trial court bought that argument. Speaking to Justice Johnson's argument about whether the town could do this again. Well, perhaps it could if the town could get past a res judicata or argument in that species of defense. The issue, though, is that it would be extraordinarily inefficient. It would be a terrible use of public dollars to have to go through this again. This is certainly a situation where this court could say the trial court abused its discretion. It got its factual analysis wrong. It wrongly reviewed the law. We are going to remand this case essentially with a finding that it was within the public good and that the town proved that at trial. And that is exactly what the town is requesting from this course in this.
Okay, your time has expired. Thank you very much.
Thank you.
Please call a conclusion of the hearing.
The next hearing for the court is scheduled for 10